Welcome to Sakshi TV special immigration talk show with attorney Ms. Prashanthi Reddy. Please note that Sakshi TV now has 5 immigration shows every week. On Monday with Somi Reddy, on Tuesdays with Kaveti Garu, on Wednesdays with Prashanthi Reddy, on Thursdays with Chand Parvatneni, and on Fridays with Banu Nindra. Please tune in to ask your questions. If you are an immigration attorney and would like to join a special shows, please email us at usa@sakshi.com or call us at 8667257441. Before we begin the show, please note that the information provided on this show is not a legal advice and for general informational purposes only. Sakshi TV or its agents will not be responsible for the use of information. If you need any specific legal advice, you can definitely contact the attorney directly. Ms. Prashanthi Reddy needs no introduction, but if you need consultation, you can definitely log on to her firm, which is www.reddysq.com. They have wealth of free information and online tools in the hands of immigrant community where you do not have to be a lawyer to understand. So without any delay, let us welcome Ms. Reddy onto our show. Prashanthi Reddy Garu, welcome back, Andy. How are you?
Good, Andy. How are you?
I'm doing great, Prashanthi Reddy Garu. Thank you for asking. So, Reddy Garu, today we thought we will be discussing a little about the family-based immigration and, their FAQs. We have quite a lot of questions, but before we get into the topic, do we have any latest immigration updates?
Not this show. Let's go on with the questions.
Great. Let's start with the basic FAQ about what exactly is a family-based immigration visa, or what actually happens here.
So a family-based immigration allows U.S. citizens and permanent residents to sponsor their family members so that they can come to the United States and they can, get green cards. This basically is the way United States government has set it up, is to promote family unity so that they can bring their immediate family members to the US and so that they can stay together, basically. So that's what family-based immigration is. As I said, it's people who are US citizens and permanent residents can sponsor their family members. And the types of family members they can sponsor are, if you're a US citizen, you can sponsor your immediate relatives. That is, immediate relatives are parents, children, spouses. You can also sponsor your siblings. And then permanent residents or green card holders can sponsor their spouses. So these are the different categories of family-based immigration, and more information as to who can sponsor who.
Yes. More information can you give on who can actually apply for this family-based immigration?
So U.S. citizens can sponsor, as I said, their immediate relative, including their spouses, their parents, unmarried children under 21, and permanent residents can sponsor their spouses and unmarried children. So these are the categories that can be you can sponsor your family for. So you cannot sponsor your nieces and nephews. You cannot sponsor your aunts and uncles. If you have to sponsor, if you're a US citizen, you cannot sponsor. If you have to sponsor children over 21, then that comes under a different category, and it takes time to sponsor them. So it's possible, but it takes time because they're not immediate relatives. So they fall under the visa cap, green card. As we have discussed in the previous sessions, that there are limited green card numbers as well, just as there are limited H1 numbers. And then India has certain percentage, 7% of those worldwide numbers. So there's a huge backlog with other categories. But for immediate relatives, as I said, US citizens, spouses, children under 21, and parents, there is no wait time. There's only the processing time, which takes about maybe 10 months, sometimes less, 6 to 10 months.
Yes. So, Ms. Reddy, let's get into the steps involved when you are applying for these family-based immigration. So, can you in detail explain about the steps?
The process involves filing a petition, then submitting the required documents. Then you have to attend an interview, wait for USCIS to make a decision. So the first step is depending on whether the person is in the country or outside the country, right? So if the person is outside the country and you're filing for them, you'll have to file an immigrant petition, which is an I-130. Once the I-130 gets approved, then the National Visa Center gets involved in it, and they ask for documents such as, for filing the so that they can get a green card. So you have to fill out a form online, and you have to submit proof of relationship documents. You have to submit affidavit of support to show that you can support your family member. So all these documents have to be submitted online. You also have to pay the fee online. So once National Visa Center approves these cases, then the next step would be to get an interview if you're in India, then the Mumbai consulate. Only the Mumbai consulate does family-based interviews, unlike H1, which is done in Hyderabad and everywhere else, Delhi, Calcutta, Mumbai. For the family-based, only Mumbai consulate does it. So there is a certain backlog. It does take some time for the persons to be called for an interview. They are sent a letter with the interview date when the consulate is ready and if the visa number is available. So as we discussed, family-based immediate relatives are always available, so they will get a letter as soon as the other preliminary steps are over. For the other categories, which are not immediate relatives, like green card holders, spouses, or children, adult children of citizens, you have to look at the priority dates. There's a visa bulletin, so when that bulletin shows that your date is available, then they'll call you for an interview. At the interview, depending on what kind of case it is, mostly spouse cases, they ask the petitioner as well to come. So the sponsor has to come for the interview as well as the alien beneficiary. And then they can either approve or deny it. If they approve it, then they will send a package. They will give you a package, a sealed package, and they will give you an immigrant visa stamp in your passport. You come to the border, you fly into the US, and at the airport, then they process the rest of the petition. You give them the sealed envelope. They will process it, take your fingerprints, and they will send you the green card in the mail. So that is if you are outside the country. If you're in the country, you'll file an immigrant petition, and you will file for adjustment of status, I-485, if your visa number is available or when it becomes available. If it's an immediate relative, so you can file both together, an I-130 and a 485. And again, the documents that you have to submit are, at the affidavit of support to show that that you will not be a public charge, that the US government does not have to be concerned about supporting you with government funds. That's what they want to make sure. And then you will have to submit proof of relationship. You'd have to submit the sponsor's recent tax returns. You have to submit your passport, proof of your status. Since you're in the US, you have to be in status. For immediate relatives, again, even if you're out of status, you can still adjust. But for other categories, you have to show your status. So you have to show a valid I-94. So these are the common documents. You submit them along with the fees and all the forms, the 485. You can submit. You get incidentary benefits when you file a 485. So the incidental benefits are the affidavit, the work authorization, and the advance parole. So work authorization allows you to work. Advance parole allows you to travel while your 485 is pending, because USCIS knows that this process takes a while. So in the meantime, they want to give you some interim benefits. So that's what these are. So you can file all these applications together along with the I-130, and you'll get a receipt to start off with. Then you will get either a request for further evidence or you will get an approval. You can also, before getting the approval, be called for an interview at the local USCIS office, depending on where you stay. And once at the interview, you could, again, either get a decision asking for more documentation in case they see that you don't have enough documentation, or you can get they'll tell you that, okay, we've completed all the paperwork and we will let you know the decision in the mail. Or at some offices, they tell you immediately that, okay, we are approving you your green card. And then what happens is they may take away your EAD since you don't need it anymore, your work authorization, as you're going to get your green card. And they'll send you the green card in the mail. So that is the process of filing a family-based petition. There's a lot more, but that will take another session. So,
so Ms. Reddy, can we talk a little about how long does this usually take? Is there any specific duration that the people can expect when they are applying for these family-based immigration?
It really depends on the USCIS workload at that particular time. The processing time really depends on that. And also, it depends on factors such as visa availability. Like I said, like the green card numbers are not available. If you're not an immediate relative, you might have to wait for years. But the processing time itself, as of now, is about 4 to 10 months. And, it is sometimes takes very less time and sometimes it takes a little longer. And within that time, usually in 3 to 6 months, you should get your EAD and advance parole. And advance parole is very important because you're not supposed to travel without advance parole if it's a family-based petition. If you travel on your underlying non-immigrant visa, say you're on a H1 and you file this, and you travel while your 485 is pending and you haven't received an advance parole yet, your 485 will get denied. So there's something to keep in mind that processing times are important because that might affect your travel plans as well. So the best thing to do is go to the USCIS website and put in the form number. Usually it's a drop down, and then then you put in the service center that it was sent to, and that will give you a good idea of what the processing times are for your particular petition at your service center. So while the case is being processed, you also will be called for biometrics. Biometrics are basically fingerprints and photographs that are taken. And then once those are taken, the fingerprints especially, they'll do a background security check. So all the processing time involves, all these steps as well. So sometimes it can take longer, but about 8 to 10 months, I would say, for people who are in the US. For people who are outside the US, it can take longer because you have to first file the I-130, wait for that to get processed. Then you have to file your application with NBC, wait for that to get processed, and then wait for your appointment date. And sometimes at the Mumbai consulate, if you're in India, is backlogged, then the appointment date, might stretch out. So that can take about 2 years because of all these different steps, because you can't file the two petitions together, the NBC petition and the I-130, you can't file it simultaneously. So that adds to the processing time when the person is outside the country. And in addition, because you have to wait for the consulate to give you an appointment, and it depends really on the backlog. For example, during COVID, or just after COVID, when the consulate opens up, they had a backlog of about 500,000 cases, about 400,000 cases. So you can imagine that no one was getting their, appointments quickly. It was taking a few years. Now they seem to have gotten through the backlog and they're much better with their processing time. So as I was saying, the processing time really depends on the type of case you're filing and where you file it.
Yes. So what kind of documents are required by the people who are actually applying for these kind of immigration-based, family-based immigration visas?
So, whenever if you go to the USCIS website, again, it's a good resource. Or, if you file the case through us, we give you a detailed document checklist. But in general, the common documents required for family-based cases are the number one is the proof of relationship. So if you are a spouse, then you would need the marriage certificate. You would also at all times need the birth certificate for yourself and as well as for your sponsor. So the birth certificate has to be given by the recognized authorities in that country. For example, in India, birth certificates are always issued by the registrar of births and deaths. So they issue the birth certificate. So we cannot get a birth certificate from the Indian consulate, for example. That will not be a document that will be accepted. So in addition to that, the birth certificate has to be registered around the time of the birth. For example, if you're born in the 1970s and your birth is registered in 1990, that is called a late registration. So if you have a late registered birth certificate, then you also have to submit secondary evidence, meaning additional evidence to show when you were born. This additional evidence could be in the form of birth affidavits from people who know of your birth, who were present at the time of your birth. And these are usually notarized affidavits stating that how they know, how they related to you, when you were born, etc., etc. You also can use school leaving certificate, like the transfer certificate from 10th grade. You can use that, the TC certificate, as proof of a birth certificate. You can also use letter from the hospital where you were born, attesting to when you were born and where you were born. So this is secondary evidence required if you either don't have a birth certificate or your birth certificate is registered late. Now, if you don't have a birth certificate, in addition to the secondary evidence, you'll also have to submit a non-availability certificate, meaning you'll have to go to that town wherever you were born and ask your that registration office to give you a certificate saying that your birth was never registered and they have no record of your birth in their database. That's a non-availability certificate. So in addition to proof of relationship, birth certificates, you also need a valid passport. Your US citizen spouse or whatever the family member, US citizen, a family member needs proof of their status. So if they're a US citizen, then their passport copy, naturalization certificate, if they're naturalized. If they're born, then just the passport copy is sufficient, US passport. If they're permanent residents, then copy of their green card. In addition to that, if you are the beneficiary, you're in the US, you have to submit your status documents, your I-94. If you're on a H1, the I-797, your H1 approval. Then you'll have to submit supporting documents. For example, in the case of a spouse, you'll have to submit supporting documents to show that it's a bona fide marriage. That's only in family-based spouse cases, because they want to make sure it's not a sham marriage. So they are looking for photographs together. They're looking for the marriage photographs, maybe the marriage a card, maybe the invitation card. They're looking for joint documents, such as joint tax returns filed, joint bank statements, joint credit card statements, health insurance, life insurance, whatever you have to have that is joint. A lease maybe, or proof that you own property together. This is all compelling documentation to show that the marriage is a bona fide marriage. In addition to that, family-based cases, the sponsor always has to submit an affidavit of support, which is the I-864. They have to show that they are willing and able to support you financially, because the immigration is concerned about you becoming a public charge, which means that you becoming dependent on the United States government for sustenance, for health, for money, etc. So they want to make sure that you're not a public charge, and if they think that you might become a public charge, they can deny the case. So the affidavit of support really helps for them to make a positive determination to show that you're not likely to become a public charge. Also, if you ever been on SSI or ever been on long-term rehab at the cost of the government, then it's possible that you will be determined to be a public charge and your case will get denied. So make sure you only take those benefits that, there are a lot of benefits that you can take. Obamacare, you can take free COVID shots, you can also take food stamps, many things that you can take, but there's some things that you cannot take, because if you take those benefits, then you will be determined to be a public charge. So contact your attorney, make sure you know what you're doing before you take a certain benefit that is given to you.
Yeah.
So these are some of the documents needed for the family-based cases.
Yes. So can one actually apply for it if they have ran out of status, or if they're not in the status anymore?
In some circumstances, they can. So if it's an immediate relative petition, which means if you are the spouse, the parent, or minor child of an immediate relative, US citizen, then it doesn't matter even if you're out of status. As long as you entered the country legally and you did not commit any crime, which could, then make you ineligible for the benefit of a green card. As long as those factors are not present, simply being out of status does not affect your green card filing. But if you're filing for a green card for the other extended family members, like brother and sister, or green card permanent resident filing for their spouse and children, then your status is important. So you will not be able to adjust in the US. You'll have to leave. And one thing to remember is if you've been out of status for more than 6 months in the US, and if you leave, you might incur unlawful presence. And if that happens, then you might need a waiver to finally get a green card while you're outside the country. So something to keep in mind. So not all people who are out of status can. Some people can adjust. Some people cannot. Some people can adjust. Hello? Yeah, sorry. Some people can adjust under certain circumstances.
Yes. Ms. Reddy, can we talk a little about how can one prepare for these kind of interviews? And is there any preparation process, and what kind of questions can, people expect, or any documents that, they can expect suddenly during the interview?
Yeah, so there are documents that, it depends on the type of case, but in a family case-based spouse case, for example, if it's a spouse-based family petition, then, as I said, there is always the question of whether it's a, bona fide marriage or not. And there's always the presumption from the USCIS side that it is not a bona fide marriage. So we have to overcome that presumption by submitting documentation and being prepared for the interview as well. So at the interview, they might ask you questions related to when you met. They could ask you questions about, do you know each other as family members? So they can also ask you questions about, and if they find out that there is some discrepancy, they can have something called a Stokes interview where they separate both of you and ask questions, and then they, it's done by the fraud prevention unit, and if they find discrepancies, they can deny the case. So they separate the husband and wife and ask them questions, and then see if they answered the same way or not. And they're looking for discrepancies. So generally, when you go for an appointment, you will get a notice. So make sure that you take that notice with you. You will, in the notice, it will mention a list of documents that you have to submit, and the list of original documents that you need, such as they'll ask you to get your passport, your ID in original, birth certificates, marriage certificates in original. You should go through your application to make sure you know what documents were submitted, that you know what was written in your forms. If any corrections are needed, you should ask the officer to make those corrections at the interview itself, because you will not get any other chance then after that to make the corrections. So important to go through it, and what will happen is the officer also will go through that 485 with you and ask questions such as your name, your biographic information, your name, your date of birth, your address, when did you last leave the country, when did you come back, travel information. And there is a bunch of questions that they'll ask you from the 485 form, which is basically you have to answer yes or no. And those questions relate to security related questions, national security related questions, whether you've ever committed a crime related to that, if you've ever helped anyone immigrate illegally, it's questions related to that. So you have to listen to the question carefully and then respond accordingly. If you don't understand the question, you can ask them again. So that's what usually happens at an interview. And then if they feel that they need more documentation, so just sometimes maybe there is some updated information. So at the time that you filed it, maybe you were working for one employer, and then by the time the interview came up, you were working for a different employer and you have a different W-2. So make sure you always submit updated information, even if they don't ask for it at the interview. So this is your chance to do that. Sometimes they might see that the taxes don't show enough money for you to be able to support that individual and their family. In which case, you can have another person submit their tax returns and fill out the affidavit of support. So the officer might ask you to submit an additional affidavit of support. They don't deny cases. They might ask for additional documentation. And this is one example. So in which case, then they'll give you time to respond to that. And then, once you respond, then they'll give you their decision. So this is what generally happens at an interview.
Yes. And also, Ms. Reddy, what can they do if their case is denied at a point, or, if they can't process the immigration process more?
So if it is denied, then it depends on why it is denied. And it's possible that you can either refile your case, or you can also file an appeal. Really depends on what the situation is. For example, if it is denied because you're not eligible to get a green card because you were out of status for some period of time, or you have a criminal case and you don't have any waiver that you can file, then there's not much you can do. There's no point in filing an appeal or refiling the case. But if it was denied, for example, because you didn't pay the proper filing fee, or you didn't sign somewhere where you were supposed to sign, or you didn't submit some documentation, then you can decide on whether you want to file an appeal or you want to file a fresh case. You might want to file an appeal if you have no other underlying status, because you may not be able to file a fresh case without, having a valid I-94. So these are the things that you have to keep in mind when deciding whether to go for an appeal or to go for, fresh filing. And also it depends on why it was denied. So if there is a chance of fixing the reason for denial, then definitely you can go with one of these two options, depending on what your status is.
Yes. And also, are there any specific rules, Ms. Reddy, where people are not supposed to work when this family-based immigration process is actually happening? Do they have any work regulations in USA or in India?
So when you file for adjustment of status, you can also file for a work authorization, the I-765 form. Now, the work authorization takes a few months to get approved, unless you have an underlying status that allows you to work, such as a H-1 or a TN, or an F-1 OPT, some such status. Then you are not allowed to work. You should wait until you get the work authorization document. You'll get an EAD card in the mail. Once you get that card, then you can work. Until then, you can work.
Yes. And finally, Ms. Reddy, is there anything that you want to cover before we end this session?
I think maybe we can talk a little bit about the interview, or so I think most of it we spoke about, but there was another question which came up about whether you can, if you don't speak the language, can you go for an interview, and can you take a translator, an interpreter, to the interview appointment. USCIS usually does not provide interpreters at adjustment of status appointments. You can, however, take your own interpreter, but your family member can't interpret for you. Meaning, if you're going with your spouse, it's a spousal case, the spouse cannot interpret, because then they don't know they're not able to then interview both of you. They're only interviewing one person. So yes, you can take your own interviewer, who can be another family member who's not sponsoring you, or a friend, or even an official professional translators. So that is possible. I think with that, we've covered most of what we wanted to cover today.
Yes. I think with that, we'll take an end for this session. Thank you again, Ms. Reddy, for tuning in. It's always amazing having you on my show. Thank you again for the viewers for watching. You're watching Sakshi TV with me, Shivani Raj.